Sarah Boone is attempting to get an entirely new trial. And of course, James Owens is all for this. Let's see what they've come up with now. Comes now the defendant Sarah Boone, by and through counsel and pursuant to Rule 3.600 Florida Rules of Criminal Procedure, files this motion for new trial, stating in support thereof the following. The defendant was found guilty as charged of second-degree murder on October 25th, 2024. The instant motion is timely filed pursuant to Rule 3.600. The defendant asserts that she is entitled to a new trial under Rule 3.600 on the following grounds. And I can see here at the bottom there's going to be more explanations of these, so I'm not going to give an opinion, or try not to, as I go through. The court erred in ruling the defendant was not entitled to court-appointed counsel. The court erred in denying undersigned counsel multiple motions for continuance. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. And V, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. So, let's begin with argument 1. The trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above-styled numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. Undersigned counsel took on the above case because he was concerned that Miss Boone would not have an attorney to present her at trial. The above case was very complex, even for a seasoned trial attorney who was the public defender in the First Judicial Circuit for years, as well as having a thriving private practice. It was apparent to undersigned trial counsel that Miss Boone would grossly ill-prepared and unequipped to handle a trial in this matter, or in fact to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111 Florida Rules of Criminal Procedure guarantee an indigent defendant the right to appointed counsel. There appear to be 2 exceptions to this precedent. If the defendant physically harms or threatens to harm, rape, battery, etc., his/her counsel, if the trial court certifies the defendant will not be incarcerated if found guilty, i.e. a judge trial. Should the court determine that the defendant was not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's right to due process, as well as the defendant's right to assistance of counsel. In the instant case, undersigned trial counsel would assert that Miss Boone's behavior did not rise to the level of misconduct to warrant waiver of the right to court-appointed counsel, and if the court determines that she waived the right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in the waiver of the right to court-appointed counsel. Under controlling precedents, failure of the court to appoint trial counsel can result in the motion for a new trial being granted. Under controlling precedents, Rule 3.111, Florida Rules of Criminal Procedure, and the Sixth Amendment, the defendant, through counsel, moves the court for a new trial. They could not be more clear to Sarah Boone what would happen if this kept happening. It was explained to her so many times, and it kept happening. Now, we don't know exactly what happened with her lawyers, but we do know from one of the letters that she was yelling over them on calls to the point where Sarah Boone would even hang up on them, and she was being very combative with them, like verbally at least. So yeah, they're trying to argue this, but at the end of the day, Sarah Boone knew what she was doing. Sarah Boone caused this, and then Sarah Boone made agreements and got a lot of things done to help her with the trial as a pro se defendant. She had access to quite a few things for her discovery that she normally wouldn't have had in that jail, so I don't know how they're going to argue that, but they are. Argument 2, the court erred in failing to grant defendants motions for continuance made by undersigned trial counsel. So, before I even read this, one of the things they did is these deadlines were put in place because this trial has been delayed so many times by Sarah Boone. There were deadlines, and whether she was pro se or not, this was a deadline. And then she suddenly wasn't pro se, and it was still the deadlines. They tried to delay so many times. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. Jones v. State. And I expect the response from the state is going to tear these apart, which is why I'm not looking into them at the moment. The laws being cited, I'm sure the state is going to do that. In the instant case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed his notice of appearance on August 30th, 2024. This gave counsel 45 days to prepare for a second-degree murder trial. The 45 days, unless I'm misremembering, that had nothing to do with him becoming counsel. Those were just how much Sarah Boone had left. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for meeting with Miss Boone and attending multiple hearings. Despite his best efforts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. A prime example would be reviewing hundreds of pages of text from Miss Boone's cell phone. Sarah had all of this in jail. She's supposed to have been reviewing all of this. She should have been able to hand over, like, this is the important bits. Reviewing all records of prior conduct, Miss Boone and the alleged victim with law enforcement. Again, Sarah Boone had all of this, including inadmissible hearsay by the alleged victim to law enforcement regarding Miss Boone being the aggressor at times. Again, Sarah should have had all this. Should have been able to point it out. Counsel for all purposes closed his law practice down to prepare for trial, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked, and as Miss Boone was entitled to under the controlling cases cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. I don't expect that to work out. I mean, we know what happened, right? If you've been following the case, you know the judge was very clear, very fair, tried to make everything as by the book as he could. And Sarah ran out the clock, essentially. He says himself, 4 years later, now she gets a lawyer she's not going to cause issues with, or at least not enough issues that they quit. The court erred when it denied a motion for a new trial due to an emotional outburst in the presence of the jury. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and depart the courtroom. Undersigned counsel timely moved for a mistrial requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. This was when George's mother had like a small outburst because she couldn't contain herself watching her son be murdered on video. She thought she could, and she was in court. She promptly left the courtroom. Why didn't Owens ask for a curative instruction, or did he not do that because he wanted to use it in this? Why didn't Owens do that if that was such a problem? The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedent, the defendant is entitled to a new trial. Argument 4. The court erred in allowing the opinion of the state's expert not previously disclosed. We went through this in court. If I'm like, maybe I'm misremembering somehow, I can't imagine, it's burned into my brain. The state had no knowledge of any new opinion. The state ran everything based off of the opinion they had from this expert from the depositions. Owens was angry that this expert didn't tell him things he didn't ask about during the deposition. He tried repeatedly to go after her for that. She did have a new opinion, but it wasn't what the state didn't know about it. Then the judge let Owens do 2 depositions in court. Owens did 1, literally walked away, and the judge is basically like, "Are you sure?" And he went back up and did it again. So this ought to be fun. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Warner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. So again, according to the state, this isn't a new opinion, right? Unless I'm misremembering. This issue was discussed extensively in the expert witness's deposition taken on October 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed to in the deposition mentioned above. She had a new opinion, but I don't think it had anything to do with imminent threat, right? Am I wrong? I was thinking her new opinion wasn't about the imminent threat. And that the entire time her testimony was very clear that Sarah Boone did not have an imminent threat at the time. And it was something else. My mind is blanking. I feel like I knew this until just the moment I needed to recall it. Exactly what the opinion was. And it wasn't a new opinion per se. It was her saying, I solidified my opinion over time later. But again, it wasn't something the state knew she was going to say. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified before the jury was improper. The state's expert, Dr. Tanya Warner, MD, admitted she had not listened to the defendant's testimony before the jury. before forming her opinion in this ultimate test of fact. In addition, Ms. Dr. Warner failed to listen to the testimony of Dr. Michael Brand and Dr. Julie Harper before expressing her opinion. So, from my understanding, she doesn't have to listen to any of this. She interviewed Sarah Boone. Sarah Boone told her things, and those things Sarah Boone said showed there was no imminent threat. You don't have to listen to Sarah Boone's brand new story, because Sarah Boone did have a brand new story once she appeared in court, because Sarah Boone lies constantly. Furthermore, the state's expert testimony on this issue, whether the defendant perceived an imminent threat at the time of the event, violates the providence of the jury. Witnesses are prevented from expressing their concerns, whether the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Excuse me. Didn't Dr. Julie Harper go into how an imminent threat can be determined and that she believes... Am I misremembering this? Like, I feel like he's literally like, we can say that this happened. Our expert can testify on this, but your expert can't. This is sounding really dumb. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. I expect that the state is going to destroy all this case law, by the way. That's just... I'm not even looking into the case law. That's my opinion right here. They're going to destroy all of it because Owens cannot do case law. We've seen that in the trial. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This testimony may interfere with the function of the trial judge to determine the applicable law and the instruction of the jury thereon. Yeah, like... I don't think Owens even objected specifically to her talking about imminent threat in court. It's been a few days. But this is just... I'm not thinking this is Sarah. I think this is definitely Owens trying whatever he can, right? Makes for a better movie. Argument 5. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. The states committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument opposed to a rebuttal. Well, good giving fucking explanation there. Wherefore, premise considered, the defendant seeks relief sought herein, as well as any other relief in which may be entitled. The defendant requests a hearing on this matter. I mean, Owens set up, here's Sarah's story of the night, right? Like, that was his closing, pretty much. Also, we traveled really far, and we're small town folks, and the big city folks are nice. Like, that style of thing. I don't know why he did that. I kept getting objections for that. He also, in his closing, decided to refer to the female lawyers as the girls, without names. And also did, boys can never hit a woman. You can never hit a girl. He tried that. But Owens, at some point in his closing, went into the facts of the day. And the rebuttal, in my opinion, was going through the facts of the day and how you don't have to believe any of those components because Sarah Boone is a liar. A repeated liar. A known liar. A drunk. Now, maybe that's not allowed in Florida as a rebuttal. But it did seem like he was rebutting exactly what the defense was trying. The defense was going up and saying, you know, if this, it takes this to be this, and this didn't happen, so therefore she's not guilty of it. And the state did the opposite in rebuttal to... I don't know. Someone else, so I'm going to have to watch some lawyers' opinions on Argument 5, right? This is one of those things where I'm going to say definitely check out some lawyers or people that have followed other Florida cases. Man, the one that really sticks with me is they did it in court too. Trying to use the defendant's family, try to use George's mother to get Sarah Boone off. They tried it in court. And the state had to explain that they have a right to be there. And the judge just completely immediately denied, probably made Owens mad, and it's probably why this is listed. He immediately denied Owens trying for, I think it was a mistrial, right? We got more Sarah Boone. I don't know. I didn't think we'd get something this early, but there's your distraction for the election day, I guess. Now we have Sarah Boone.